If you're an American living abroad, maybe you moved to escape sky-high taxes, endless regulations, or maybe you were born there. Or maybe you fell in love. But here's the reality. Most expats discover this too late. When it comes to estate planning, leaving the United States does not mean you left the IRS behind. It doesn't matter if you've been gone 3 years or 30, as long as you are a U.S. citizen. The United States claims the right to tax your worldwide estate, your lifetime gifts, and in many cases, you may even need to worry about the inheritance rules from a state you left decades ago. Hi, I'm Anthony, parent of IRS Medic, one team legal and tax, and every week I upload new content like this that could help you save your fortune. Be sure to subscribe, and if it's not too much, give me a little like, which will help others see this content. You see, at the same time this is going on, the country you now call home has its own inheritance taxes, forced heirship rules, and sometimes its own probate system. You're no longer dealing with one set of laws, you're caught between two, and most expats have no idea how dangerous that can be. The single biggest misconception I hear every week is my assets are overseas, so they're not subject to U.S. estate tax. That is completely wrong. If you are a U.S. citizen, the U.S. counts everything you own anywhere in the world. Your house in Portugal, your bank accounts in Singapore, your flat in London, your business in Thailand. It's all part of your taxable U.S. estate. The IRS doesn't care that you haven't set foot in America for 20 years. That misunderstanding creates 4 massive risks that catch almost every expat family off guard. First, double taxation. Many countries impose their own inheritance or death taxes, and the U.S. can tax the same exact assets again. The United States has estate tax treaties with only about a dozen countries. Just because the country you are in has an income tax treaty with the U.S., it does not mean there is an estate or gift tax treaty as well. Families lose millions because they assume the two countries will sort it out. Well, they don't, or they will settle it out with your money. Second, holding the wrong assets in the wrong way. Expats naturally use the investment and retirement vehicles that make sense locally, but many of those are toxic under U.S. rules. Adding fuel to the fire is this is my pet peeve. The IRS is intentionally vague on many tax treatment. Trust me on this. This leads to the tax industry creating a lot of law. I am serious. It is easy to find a tax professional who will suggest a ruinous tax treatment for PFICs, foreign pensions, foreign life insurance, and trusts. All punitive tax rates. These tax industry gurus will follow each other as a source, but when you ask them to point to something official, they can't. Fortunately, many have reached out to my firm at irsmedic.com for an incredibly valuable second opinion. If you're married to someone who is not a U.S. citizen, which is incredibly common for U.S. expats, the unlimited marital deduction disappears. Lifetime gifts are capped at roughly $185,000 a year, and at death, you could be forced into a complicated Q-dot trust so the IRS won't take 40% right off the top. This one rule alone wipes out more expat estates than almost anything else, as marrying a foreign spouse is incredibly common. Fourth, failing to sever ties with an aggressive U.S. state. California, New York, Massachusetts, Maryland, and a handful of others do not let you go so easily. If you don't formally break domicile, they can still claim you for estate tax, income tax, and probate purposes, even if you lived abroad for decades. Most expats never contemplate the paperwork to cut those ties cleanly. Every expat has to answer these 3 critical questions. First, in what country do you want your estate to be administered and probated? Second, which country do you want the tax authorities to consider you to be domiciled in? And third, which assets should stay under U.S. jurisdiction and which should be held abroad for maximum tax efficiency? Get any of those wrong, and the results are catastrophic. Good expat estate planning doesn't mean picking up one country's rules and hoping for the best. It means creating a coordinated plan that usually includes a U.S. compliant will or some sort of trust, a separate local country plan that works in harmony with it, careful use of specialized trusts like the Q-dot I mentioned before, or foreign grantor trust, deliberate avoidance of non-compliant investments, and we don't want that, and when possible, leveraging the few tax treaties that actually exist. Most estate lawyers in the US have never dealt with foreign death taxes or forced heirships. Most international advisors has never touched US estate tax or citizenship-based taxation. Expats fall straight through the cracks. True cross-border planning has to integrate everything: US estate and gift tax, the foreign country's inheritance rules, your immigration status, treaty analysis if any exist, and your domicile strategy. And also, you may have probate in 2 jurisdictions at once. If you treat this like a regular domestic planning, you don't have a plan, you may have a very expensive time bomb. So if you're a US citizen living abroad and you want to protect what you've built, eliminate or minimize double taxation exposure you have, and make sure your family actually receives what you intend them to receive, book a consultation on the link below. Cross-border estate planning is one of the most complex areas of law on earth, and the cost of getting it wrong is measured in millions, not thousands. Now, where we have helped out incredibly is with expats who are not in tax compliance. We are the leading offshore disclosure firm since 2009. We have successfully opted out more taxpayers from punitive penalties than any firm I know, because we really enjoy being advocates for our clients. So if you are not in IRS compliance now and are worried about receiving an inheritance from the US, no worries. We help thousands of expats just like you resolve their IRS compliance issues effectively. We really enjoy helping global families make sense of this all. Book a call right now at IRS Medic to speak to me or one of my team members. And if you're worried about protecting your stateside parents' estate from long-term care costs, check out the next video right here on why Medicaid rules are completely different in every single state. You'll see why generic planning simply doesn't work there either. This is Anthony Parent of IRS Medic, One Team Legal and Tax. Thanks for watching.